Assalamu alaikum. We'll just start with the recitation of Quran.
أعوذ بالله من الشيطان اللعين الرجيم بسم الله الرحمن الرحيم والعصر إن الإنسان لفي خسر إلا الذين آمنوا وعملوا الصالحات وتواصوا بالحق وتواصوا بالصبر صدق الله العلي العظيم اللهم صل.
Okay, so we're going to get started slightly later than what we'd hoped, but we've all got a bit of food in us, so hopefully we'll be okay. The slide comes on. It's what we practiced earlier. There we go. So we've got quite a few seminars coming up for HIC education. So we've got one this Friday. At the end of the presentation, I'll tell you about the one next Friday, one in November, and one in December for now. So if we go on to the next slide. And I'll ask Mullah again to answer the question or to tell us about the importance of having a will from an Islamic. Just a slight overview, and then Sister Mariam will take over.
Bismillahir Rahmanir Rahim. The question that is the importance of having a will. Number one, as we will go through the slides that will be presented by Sister Mariam here, but I just want to mention the importance of having a will is something which is emphasized in the Holy Quran. Again, it has been emphasized by the Holy Prophet sallallahu alaihi wa alihi wa sallam. Allahumma salli ala Muhammadin wa. And Aimma Tahirin alayhimus salam, they have all emphasized. Now there must be wisdom, there must be reason as to why Quran puts that emphasis, why the Prophet and the successors of the prophets have emphasized upon having a will. When we talk about will, we are talking about that you as an individual are allowed to dictate as to how 1/3 of your wealth, right? 1/3 of your wealth after your passing away, how should it be distributed? That is what we call in Islam as wasiyah. The 2/3, the division of the 2/3 is according to what Quran says and according to the guidance provided by the Prophet and Aimma Tahirin alayhimus salam, which for us has been provided in the books of the Maraj, telling us that if there is one son, one daughter, okay, if there are two sons, one daughter, if the wife is still alive, how is it distributed? All comes from 2/3. When you talk about 1/3 is where I and you are allowed to say, this is where my money is going to go. This is what is called wasiyah. And finally, the last point that I want to make is, I have come across many instances here, again in East Africa, in Madagascar, where people did not write their will, and how the children have fought with each other, taking them to the court. cutting off the relationship between each other. All these are disadvantages. Why not be prepared, as I said in the afternoon today, for Jummah khutbah, that when we want to go for a journey in this world, we make all the preparation. The journey in the hereafter is definitely going to take place. Why not make preparation? Wasiyah is one of the way. Wassalamu alaikum wa rahmatullahi wa barakatuh.
I'd also like to introduce Nick, who's going to say a few words in regards to the company. He's given up, him and Sister Mariam and Husaini have given up their time to come along and inform us about this.
Firstly, I'd like to say thank you for inviting us. It's an honour to be here. I come for a certain disadvantage in that I'm not an expert in Islamic wills and jurisprudence, but the good news is we do have one with us. Let me tell you a little about our company, W&P Legal. We're based quite locally. We're based in Market Deeping. Many of our clients live in Peterborough and the surrounding area. We have been a law firm that specialises only in wills, probate and inheritance for the last 18 years. I founded the company 18 years ago in October of 2005, and we've grown to be one of the most respected will probate companies in the UK. My pleasure tonight is to introduce you to Mariam Khan. Mariam is having somewhat of a homecoming, she tells me. She used to come to this mosque when she was a little girl, many times, and she's delighted to be back here. She's quite shy. She's very knowledgeable. In fact, we call her our unicorn in that she is one of only 2 women in the UK who has qualifications in Islamic jurisprudence as far as wills and probates are concerned. We sent her over to Pakistan just before the first lockdown. She was supposed to go for 3 weeks and ended up staying for 3 months because she was locked down over there without her children. But she was able to study during that time and get her qualifications in jurisprudence over in Pakistan. She has a really good presentation for you tonight. Hopefully it will make you think. Hopefully it will make you assess your own situations. And most of all, hopefully it will make you take action. But with that, I will let Mariam take the reins and talk about Islamic inheritance.
Assalamu alaikum. Thank you so much for joining us today. Thank you, Nick, for introducing me, and thank you, Mulana Saab, to allowing us to come here and delivering this very important seminar. There are 5 points that I would wish to explain today and go through. See if I've got the correct slide. Do I click it? There we go. So, as Mulana Sab has mentioned, why do you need an Islamic will? Obviously, it's been mentioned in the Quran and by our beloved Prophet, peace be upon him. I also will be discussing what will happen if you die without a will, so the consequences are. We also shall be touching upon inheritance tax. This is something that it is payable if the will, or if you don't have a will, or if you die with a will, but it's not tax efficient. What is the Islamic laws of inheritance? I'll explain briefly what Islamic laws of inheritance are and how it would work in a simple scenario. As I said, every scenario is different, every family situation is different, but this was giving the most basic sort of idea how it works. And then finally, we'll discuss how do you make an Islamic will which complies with Islamic laws of inheritance and English law. Okay, so as you know, it's been mentioned in the Quran in Surah Al-Baqarah and Surah Al-Nisa very clearly that how the inheritance should be distributed between the primary beneficiaries, your beneficiaries. I'm not going to obviously read this out, but as you can see on the screen, these are the main verses in the Quran that mention the distribution of the Islamic law of inheritance. So as a Muslim, we're quite lucky in words, where the reason being is when we get clients, majority of the non-Muslim clients, and they say, okay, we would think about who our beneficiaries would be. In terms of Islamic or Muslim clients, it's very easy because we know Allah subhanahu wa ta'ala has also mentioned, already has mentioned in the Quran, these are your primary beneficiaries. This is who you can give your assets to. So we don't need to think about it because we know it's there. As we mentioned before, that there's 2/3 of your assets is distributed according to the rules of Islamic law of inheritance. So 2/3 is already decided by Allah subhanahu wa ta'ala, and this is how you should go about it. The 1/3, of course, you have a choice. You can give that to anyone, a non-Muslim family member, charity, anyone. It can be anyone besides the primary beneficiaries. Okay. So, again, the importance of an Islamic will. It will protect yourself, first of all. How it's going to protect yourself is when you're writing an Islamic will, you'll have a shahada clause. So if giving declaration of your faith, okay, that's the main thing. So whoever's going to open the document while doing your probate at the time, or the funeral at the time, they will know, okay, this person is a Muslim, this is his shahada, okay? There has been scenarios a few years ago where there was a doctor who was from abroad, I think one of the Arab countries, who came to UK. Unfortunately, he passed away. He did not have a wasiya or any sort of documentation in place stating that he's a Muslim. His fellow colleagues who are non-Muslims obviously cremated him because they wasn't sure, how to go about his funeral. So this is something that's very important. We are very, very lucky that we have masjids here. We're, living within the Muslim community, but we do have, brothers and sisters who are from other countries who do not have that community or living in certain areas who do not have that. So this is something that's very important to have in place. And Islamic will also protect your family. As Maulana Sahib has also already mentioned, disputes. So when one dies, they have disputes between, especially the siblings, who will get what. So it will avoid those disputes, family disputes, this is one of the main aspects of Islamic inheritance. This is one of the main reasons that Allah subhanahu wa ta'ala has mentioned in the Quran and our beloved Prophet has guided us, is to avoid these disputes. It will protect your children. The most, I think, important thing, the most important asset we have is our children. So if we have children under the age of 18, you need to appoint a guardian. So God forbid something happens to you or your spouse, who will take care of your child. You need to appoint that. Who is the best person to take care of your child, rather than the authorities. You don't want them to decide. So that which person would be more suitable to take care of your child if God forbid such situation arises. One more very important point is protecting your body. Again, we stipulate funeral wishes. Okay, so Islamic funeral according to your traditions. You can also mention where your janazah will be parade, how it will be parade. You can also mention how your ghusl will be performed. Okay, or who will perform your ghusl. You can also mention that as well. It's an option. One most important thing I believe is that we mention in the Quran, it's like a default, not in the Quran, sorry, in our wills, and it's a default clause. What we say is that no autopsy, embalming unless it's required, which is haram. Okay, many years ago, back 1997, when my father died, and because my granddad was in Pakistan, so Mum had to take my dad to Pakistan for his burial there. Unfortunately, that time did not have much knowledge, and they did do embalming in order to preserve the body to go to Pakistan. Obviously, 3-4 days of journey, and then to do the transportation and all that in order to preserve the body. Now, but obviously they didn't know it, but it's haram. All our life we don't even touch alcohol. We don't even go near it, and then all of a sudden we die. We are wrapped in alcohol. It's not right. So this is something that you must mention. However, in terms of autopsy and postmortem, it is that we can say no autopsy and postmortem unless, God forbid, Khudana Khasta, it is required. Suspicious circumstances such as murder, Khudana Khasta, or stuff like that. And then obviously that's something that is not under our control. And also the fifth point is protect your obligation. Allah subhanahu wa ta'ala has mentioned in the Quran, guided by the beloved Prophet, that you must act upon what Allah has said, is to do justice, to give your assets to your Islamic beneficiaries. Your unperformed zakah, for example, unpaid, sorry, if you haven't performed Hajj, you can mention that, that's an obligation. If you have missed your fasts, you can mention that into your will. Missed Salah, we know that Salah is something that's very important. You can also mention that into your will as well. So anything that, that's obligation towards Allah subhanahu wa ta'ala, and that we should make sure that that has also been done. Protect your future, which is very important. We believe that when we die as a Muslim, our assets will remain here in this dunya, our deeds will go with us. And deeds are such as Sadqa Jariyah, continuous reward, obviously our children, inshallah, but also a contribution to a charity. So as it says, Mulans have said, 1/3 of your asset, you can give it to anyone. You don't have to give the whole 1/3. You can also say a certain percentage to a charity organization, so that you're protecting your future by, a Sadqa Jariyah. Next. Oh, sorry. There. Okay, so this is the funeral. As I mentioned before, you can stipulate your funeral in a will. So when you're writing a will, we have a shahada clause, first of all. Then we have your funeral wishes. So you can stipulate what your funeral wishes are according to your wishes. And after that is inheritance. So obviously you distribute your inheritance, you divide it between Islamic, your beneficiaries according to Allah subhanahu wa ta'ala's command that's in the Quran. Oh, sorry. I did. Right, so debts obviously, which is need to be paid. That's also will be mentioned obviously in your will as well. So before the inheritance is distributed between the beneficiaries, your debts are paid. So it can be your mortgage, your loans, but also debts from family members such as, that needs to be paid off as well. Next slide. And then obviously earn Allah's pleasure, Allah's reward. Allah has told us how to distribute your assets, and the way we would inshallah follow it, and Allah Ta'ala subhanahu wa ta'ala will definitely reward us for that. Next slide. Okay, so that was the main reasons of writing an Islamic will. And now we will touch upon some inheritance tax issues, which is one of the reasons why we do have Muslims and non-Muslims writing wills. A second. Right, so inheritance tax. So if you have assets more than £325,000 and you die, anything below that will be taxed 0%, anything above that will be taxed 40%, unless you have a tax-efficient will. Okay. Yes, there are spouse exemptions, which you can minimize inheritance tax. And yes, you can set up some trusts, which also allows you to minimize inheritance tax. There's also, I would like to mention one more thing, is a nil rate band, a residential nil rate band, which is £175,000 if your residential property is going to your lineal descendant. So for example, your children, then you can also have that extra exemption as well. Next slide. So, an example, what I'm giving is, this is Brother Zaid, who unfortunately passed away, leaving behind his wife, his parents, and his 4 children. So upon Brother Zaid's death, his wife shall receive 12.5% of the estate. Mum and dad, both mother and father, Abdullah and Hafsa, shall receive 16.67% of each. And the children should receive a 2-1 ratio. So the son and the daughters have 2-1 ratios, which means Ahmed and Ali is 18.06%, Fatima and Zainab 9.03%. So this is like a simple scenario. Next slide, please. Right, so we do get questions where they say, Mariam, why can't we write an Islamic will online? Yes, you can do that, but there are some consequences, such as inheritance tax consequences. So if someone has gone ahead and written an Islamic will, but did not consider the tax consequences, and did not make sure that it is according, the most tax efficient will, and if it's not done that way, then there'll be some tax consequences, which means that, for example, Zaid's estate is 1.2 million. This is including his businesses. His wife, Amina, will receive 1/8 of the estate, as I said, 12.5%, so around about £150,000. And mum and dad, Khadija and Abdullah, shall receive £200,000 of his estate, and the remainder will go 2-1 ratio between the children, which is absolutely fine. But because this is not a tax-efficient will, what will happen is that there's a nil rate band of £325,000, so that's not tax, so you can minus that. And the spouse, so whatever a spouse receives, you get a spouse exemption. So £150,000 the spouse shall receive, that will be taxed at 0%. And if there were businesses, so you own some businesses, and you can get a business property relief, which is £250,000 in this situation because his business is worth £250,000. In order to get this relief, you don't automatically get it, you will need to apply for it. There's certain conditions that you need to meet, such as you should own the business for more than 2 years, you should own the business in a certain percentage, I think it's more than 10 or 20% of the business that you should have the ownership of, then you can get these sort of exemptions. Additional exemption, there's £175,000, as I mentioned before, of a residential nil rate band as well. So these are the exemptions that you can get, but you do not automatically get these, so you need to make sure that whoever's dealing with the probate at the time has claimed these properly in order to minimize your inheritance tax liability. So we've applied for the exemptions, and the total taxable estate is £475,000, will be taxed 40%. Next slide, please. Which means upon death, the tax bill will be around about £190,000. No? Okay, so I'll continue there. So this is the tax bill, £190,000, and this is something that's very common. We do get cases where the tax bill is quite high. When I first started will and probate services I think this is back in 2019, one of my first probate I did, and we're still dealing with that probate actually, is where a young lady who passed away at the age of 40, leaving behind 2 minor children. Unfortunately, there was no will in place. She had a lot of buy-to-let properties, which attracted a lot of inheritance tax. And I remember speaking to Nick, and he was explaining to me this is how much hundreds of thousands of pounds of inheritance tax was payable at the time, which was quite a lot of money. So in order to minimize this, next slide please. So in order to minimize this, what we could do is we can write an Islamic will, but a tax-efficient Islamic will, where we can put a trust in the will. So which means that because the 12.5% will go to the wife, the remainder is taxable. Okay, so minus the exemptions and reliefs. Now, in order to have that tax-efficient relief or use the spouse exemption, we can put a trust in the will, which will allow Amina, who's the wife, to receive income from her husband's estate. Okay, which means that at the date of death, at the time of death, when we're doing the inheritance tax calculation, by putting a trust in the will or making a tax-efficient will, it will minimize the inheritance tax bill to, that's not the correct slide. Okay, so the inheritance tax bill will be £0. £0. There's no inheritance tax, just by putting that trust in the will. Okay, so by using the exemptions, by claiming the exemptions properly, and having a tax-efficient will reduce the inheritance tax liability to £0. Again, every situation is different. So this is just like a simple, basic sort of an example I've given you. But yes, this is a simple sort of example that may apply. So the trust, as I mentioned before, it will distribute all of the assets into all the life interest trusts with the wife. So she will be the life interest trust of the estate, where she can receive the income, overriding everyone's powers as beneficiary's power, and tax bill will be 0. And this is the most tax efficient way as well, which means that, for example, where there's a house, and so the wife will inherit 12.5%, but the remainder can go into a trust, which means at the end of the trust, the Islamic beneficiaries can receive that. But during her lifetime, she can still remain in the property. So we do have situations where we do get some clients, especially the females, saying that, what if, the beneficiaries say, out, we want the house. So it gives that extra protection to the female as well, for this the surviving spouse. It can be the husband or the wife, can remain in the property, live there until the trust ends. So they can actually end the trust whenever they like to, but normally trust runs for 125 years. And the trust will go to the beneficiaries. By doing this, it will give her or him the right to live in the property, and also minimize the inheritance tax liability. Next slide. Right, so the next thing I would like to discuss about is a disabled child. So yes, you should write a will, which will minimize the inheritance tax, but also there's important to write a will if you have a child who has a disability, if you have a disabled child. The reason being is if the parents pass away and the disabled child receives the inheritance directly to him, what would happen is that their care package will cease, and what will happen is the authorities will start using his inheritance instead of the care package, instead of the benefits he received. And then at the time when the inheritance, they finish, there's nothing in there, they'll put them back into the care package. So in order to protect your child, you will put his or her asset into a trust, appointing 2 trustees, where they have the power to manage the financial assets of that child. Which will then happen is that the authorities will not have access to that money. The care package the child will continuously receive the care package, and it will not affect him at all. So the trustees can use it for wedding, Eid, birthday, holiday, for the benefit of that child rather than the care package. And also, lasting power of attorney. Again, a will is you write a will and it becomes into force once you have passed away. So that's a document stating your wishes. So once you're gone, that document will state what your wishes were. Lasting power of attorney is something during your lifetime. So lasting power of attorney is where you're appointing, I'm the donor, I'm appointing attorney, can be my husband, my daughter, my son, my family member who's over the age of 18, to make decisions if I fall ill, if I lose capacity, God forbid, end-of-life decisions, where they can step in and make those decisions in behalf. And again, for children, disabled children, if the child reaches the age of 18, parental rights cease, and at that time you need to have a lasting power of attorney in place in order to make decisions on behalf of your child as well. Next slide, please. Right, so a valid will. A will be valid. The will that we draft complies with the Islamic law of inheritance and the English law. The basic English law requirement is that the testator, the person who's writing a will, should be over the age of 18. You should have sufficient capacity. You should know what you are writing. You should understand that this is your will and you're giving away these assets once you're gone. You should have sound-minded, and there should be no undue influence. And then you should also sign that will. Again, it's a testament. There should be a declaration of the will, and there should also be a revocation clause, which means if you have any previous wills, once you've signed this will, your previous will will automatically revoke. And of course, at least you should have one beneficiary when you're writing a will. Next slide. So when you're writing a will, or when you are thinking of having a will in place, these are some factors you should take into consideration. Is who's going to be an executor? There should be more than one. We recommend to have 2 executors. If one executor is not there, is unable to act, somebody else can step in and manage your affairs. You need a guardian. So if you have a child under the age of 18, who are you going to appoint as a guardian? So this is something you need to think about, once you're considering to write a will. You should also consider, obviously, yes, at the time, once you've written your will, you need to sign it, and you need to have 2 witnesses. The witnesses cannot be your beneficiaries, but what we normally have is that you can come to the office and we can witness your document for you. Next slide. As I mentioned previously, lasting power of attorney. So lasting power of attorney are 2 sort of documents. Again, these are, you will appoint attorneys. Attorneys can be a family member, your spouse, somebody that you trust, over the age of 18 to make decisions on your behalf. So there's 2 types: property and finance, to deal with your financial assets, and health and welfare, to deal with your medical needs. We had a scenario during the lockdown when we had a person who contacted us who's in his 80s, and he wasn't able to obviously go to the bank or have access to his financial bit because he was self-isolating during lockdown. So what we did at the time was that we actually drafted his lasting power of attorney, so his attorneys can go out and make those financial payments and have access to his bank account and all. The important thing of lasting power of attorney is that it will protect you and from fraudulent transaction. Okay, so the attorneys cannot just go ahead and do a fraudulent transaction because they are bound by the law. If they are, they will get into trouble. So this is something that you need to. You can't just give your bank card to your son or your daughter, which we normally do, and say have that. But this is something that's good to have in place, so that if you're in such a situation, your attorney can go ahead and make, mortgage payments, bills, any financial transaction that needs to be done. They can go ahead and do that. Same with the medical health and welfare. There's several different scenarios. Scenario that I had was that back in 2019, my mum wasn't feeling very well. She was referred to the hospital to get some checks. I went with mum, but unfortunately I wasn't allowed to go inside with her while she was speaking to the consultant. The reason being is I didn't have a lasting power of attorney in place. This is when it actually hit me, because normally I go with mum to the hospitals all the time. This was the first time I was stopped, and this is because they can be undue influenced by a family member. So unless you don't have these documents, the doctors, the GPs the consultant can actually stop you and not give you any sort of information in regards to your family member. So this is something very important. I think it wasn't common a few years ago, but now it is very common. This is something that you need to do. An example is that my brother, who is currently studying medicine, and he's actually said, Mariam, there is actually a module on the lasting power of attorney. So as a GP or as a doctor or as a medical staff, this is something that they are studying, and they are actually bound. So they have to ask their patients that if they have this sort of documentation in place. Next slide. And most importantly, what I would say is end-of-life decision. Once you have lost capacity, you're unable to make decisions for yourself. Would you like the doctors to make the decision or your family member? If you want your family member to make the decision, then you need a lasting power of attorney in place so that they can override the doctor's decisions. Obviously, it has to be the best interest of the patient. The last bit I would like to talk about is probate. I do get people asking me, Mariam, what's probate? We do understand there's wills. Yes, it's a document you need to put into place, stipulating wishes, but what is probate? Probate is a process that once one has passed away, you would have to go through in order to transfer the property to assets from the deceased estate into given to the beneficiaries, of course. And if you have a will in place, it can be so much easier, because then we can just follow the will. Okay, there's an executors in there, right? The executors will appoint ourselves or any other law firm to deal with the probate. So it'll be so much easier, the process, and the court will understand, okay, these are the beneficiaries, this is how you go about it, these are the guardians, and so on. When there's no will in place, and when there are family members, it's quite difficult to go through probate when there's no will in place, and the siblings wouldn't agree who to appoint who to instruct, for example, and it can cause a lot of chaos. Next slide, please. So the important functions of a probate procedure. So when we're going through probate, we'll collect all the possessions and the assets. So what we will do is ask the executors to give us the details in terms of the estate. So how much is in the bank, maybe, for example, the valuation of the property, of the assets, all the valuations we get together, put into one pot, and we determine what the valuation of the estate is. And then we'll make sure if there's a property, and we'll make sure the property is preserved. If there's other assets, make sure it's protected and preserved as well, such as if there's empty property, we'll make sure that there's insurance to cover burst pipes and stuff like that, so which is very important. Once we've done that, obviously you have to pay all the debts. The debts will be paid once we've got the grant. But what happens is that we'll collect all the assets, the valuation of the assets, so investments, pensions, life insurance, valuation of your property, your assets, your jewellery, every single thing that you own at the date of death will be evaluated, and then everything will be declared with HMRC. So there's some IHT forms that we have to complete, and then declared it to HMRC. They will then see, okay, there's tax, or maybe there's no tax. Once they're happy, then we will then apply for the grant of probate to the court of probate. And then obviously once we've done that, it will then distributed according to your will. If there's no will, then the rules of intestacy. Next slide. Okay, so I'm just going to quickly, briefly explain the rules of intestacy. So the rules of intestacy is when you die without a will, your estate will be distributed, will be given to the beneficiaries according to the English law. The first £322,000 will go to the spouse. The remainder goes between the spouse and the children. Whatever goes to the spouse is exempt. There's no taxation. Whatever goes to children will be taxed 40%. And that is against, obviously, it's going totally against the Islamic laws of inheritance, because Allah subhanahu wa ta'ala has decided the way that our assets should be distributed, and it's going totally different way. Now, if we were living in an Islamic country, it's absolutely fine. We can just leave it because it will go according to Islamic laws of inheritance. Because we live in a non-Muslim country, we need to make sure that our assets are, given to the rightful beneficiaries that's mentioned in the Quran and guided by our beloved Prophet, peace be upon him. So what we've discussed is that we need to ensure that your wealth is distributed according to the Sharia, the Islamic laws of inheritance. Muslims who think that they have inheritance tax situation must seek professional advice. So obviously we are here to obviously guide you how to minimize your inheritance tax. And one of the most important part what I would mention is that to avoid these disputes between your family members. So that if you have siblings or children, they might disagree. You should definitely have a document in place so that it causes less chaos. Yeah. So Jazakallah, thank you. Any questions?
So without going into any detail, I'll just ask the question, can the English law supersede the Sharia law as far as a will is concerned?
If the will is correctly drawn, if the will is correctly made, then no. Unless the beneficiary has passed away. But other than that, no.
In case of a dispute?
Well, Nick, is that your answer? Is it me to answer? Yeah, Nick will take that.
So English law lays down very clearly who can make a dispute against a will. There are 5 categories of people who can bring a claim against a will. The first category is a spouse. The second category is a former spouse who is not remarried. Third is a child or somebody who's treated as a child of the family. Somebody who's being maintained by the deceased in the 2 years prior to their death, or somebody who is living as if they were husband and wife or civil partners for the 2 years running up to the day of death. So there are only 5 categories of people who can actually bring a dispute. You'll note from those categories, parents, for instance, can't bring a challenge. So if you don't have a Islamic will that specifies the correct distribution, your parents don't have the right to bring a challenge against that. So in those circumstances, English law can override, but it's only if the person who's making the challenge has not been correctly provided for in the will. So as Mariam says, if the will is drawn, the distribution is a Sharia distribution, but the will is drawn in line with English law, then it's highly likely that it wouldn't be overturned.
Power of attorney.
Power of attorney. Yeah. Okay. Now, what is the difference on this one? Plus, which will be the cheapest way? Because I know power of attorney to do it is quite expensive.
Okay.
That's what I think.
Okay. I've got good news for you on that score. So essentially, your will is the planning before you die. Probate is the process after you die.
Okay.
A lasting power of attorney is a document that gives somebody else the power to make decisions on your behalf if you can't make them for yourself. Now, they're all separate things. By having a will doesn't avoid the need for probate, but it does make it less complicated and therefore cheaper. Having a power of attorney doesn't mean you don't need a will. But the good news is, if you do it all at the same time, we do give you quite a hefty discount, so you'll be all right.
You can't tell the example how much power of attorney, because I believe in that will and that one, power of attorney is more stronger than will, I think.
So
When you have a family, okay, when you want to distribute your thing, you know.
So with power of attorney, it doesn't give you the right to distribute. It's only about keeping you safe while you're alive. If you can't make decisions for yourself, the will is the only thing that can distribute your assets after your death. Your power of attorney dies on the day you die, so it has no effect once you're dead. In terms of costs. Typically for a family, if you're making an Islamic will, you've got husband, wife, children.
Yeah.
You need 2 wills, one for the husband, one for the wife. You need the trusts, so we minimize your inheritance tax, so you don't pay inheritance tax. And then you have 4 powers of attorney. So each of you would have a health and welfare power of attorney, and each of you would have a property and financial affairs power of attorney. Now, if you buy that as a package, we charge £1,350.
How much?
1350. 1350.
135.
It was a good try.
No.
So
135.
1,350. Yeah.
But if you have a
But if you buy them all separately, okay. Let me give you some context to that. If you go to maybe Buckles or Greenwoods or Hegarty's, one of the big solicitors in Peterborough, for the same thing, you'll pay nearly £4,000. So we're very much cheaper than.
But trust is more expensive, yeah.
No, that includes the trust.
But it's not better that this than will the trust.
The trust is in the will, so the trust is declared in the will. So it's part of the whole process.
So what you suggest? You should have to have a will or a trust.
You have a will with a trust. So the will declares the trust.
Thank you.
Yeah, sorry. Any questions have to be in the mic because we've got about 20 people watching online.
Hi. Mariam, you mentioned that you can decide what to do with 1/3 of the residue of your estate. So I don't know if I misunderstood, but can that go back to your primary beneficiaries, or it has to be completely separate? So it can't be your children or your partner, it has to be like somebody else.
Mulana sir will discuss it with you afterwards. Okay, so there's different school of thoughts. Yeah, I wouldn't. Yeah.
Sorry, is that also things that fall out of the estate? If you've got like a lump sum from your pension or something, does that have to be divided in accordance like 2/3, 1/3, or can that be payable to like if you've made a nomination?
If you made a nomination, so make the nomination according to Islamic laws of inheritance.
Okay.
Okay, then it will fall out of your estate. It will not be taxable as well. So in inheritance tax purposes, we do recommend have your pensions, your life insurance to be nominated beneficiary, so it does not fall part of your estate in terms of inheritance tax. And when you're nominating them, and try to do it Islamically, so that they can receive this Islamic shares.
Okay, thank you.
Unless during your lifetime you can give whatever to anyone. Islamic law of inheritance only applies once you've passed away. So during the lifetime, if you want to give it to somebody, you can give it. So for example, some parents do say, we want to give it to our daughter, we want to support our daughter, by all means, you can give it during your lifetime. During your lifetime, you can give it to your neighbours. It's fine. It's only applies, Islamic law of inheritance only applies once you're gone. Of course, yeah.
So the will becomes legal at the point of sign-off and being witnessed. If it's not signed off, it's not a legal document. Okay, thank you. And then the other question regarding the 1,350 is just the initial package to prepare the stuff. But if the law changes, things change in the family, then is there amendment fees?
Yes. The way we work with all of our clients is we call it a review. A review is rather a grand description of what it is. We will phone you or write to you every 2 years and ask you a simple question. Has anything changed? The good news is it's nowhere near 1,350 to make an amendment. It's £79 per document, so it's really straightforward.
Mullah sir, question for you, or on the Islamic side of things. The rules of the 1/3, 1/3, and 1/3, if by consent they were changed, can they be changed after death? So, for example, a person dies and the children say, no, we don't want the money, we want it to go to our mum. Can that be by consent changed?
So, in the 1/3, has the deceased made any, given any instruction?
During lifetime. So during the lifetime of writing the will itself, can that by consent be changed so that it falls
After the deceased has passed away. See, the point is this, that 1/3 is for the deceased to instruct. Okay, so it says, for example, just read out one rule here. If person makes a will that 1/3 of his estate must be sold and proceeds from it must be spent in a particular way, his words must be acted upon. So my point is to say that in 1/3, if the deceased has already instructed and says that this is how it is going to be divided, okay, then it has to be acted according to the way he has said, okay? Now coming to the 2/3, in which you are there, your brother, your sisters, whoever they are there, if you all decide that we want to give everything to our mother, okay, There's no problem with that. But in the 1/3, it is the deceased instructions. In the 2/3, you can decide.
So if I'm
I'll just put an English law spin on it as well, if I may. Clearly it is acceptable under the Sharia to make that amendment to the 2/3. The English law allows you to do something called a deed of variation. That deed of variation must be executed within 2 years of the death. So you are able to do it under the law, but it has to be done within 2 years of the death.
Sorry for a late attendance. Question is quite simple. If the property's been paid off and I die, example, then my wife and my 2 boys, so all the asset would channel to my wife, and then my wife would channel it to my kids eventually. How does all that work? I have an official will. I have written an official will through the lawyers, but how does it exactly work? Basically, what happens?
So that is the probate process. So what happens is your executors, the executors you've named in your will, are responsible for declaring your affairs to HM Revenue and Customs and to the court. When they've done both of those things, the court will grant an order, which is called a grant of probate, and that will enable your executors to distribute your estate as you have set out in your will. So they will make the property transfer, and they will transfer the funds to the appropriate beneficiaries. So for savings, yes. Pensions are different, because normally during your lifetime with a pension, you will nominate the beneficiaries. So you will have told your employer who should be the beneficiaries of your pension scheme, because the pension scheme doesn't come into your estate for the purposes of inheritance tax. That's the nomination form. That's the, yes. Yes, so that asset won't form part of your estate at your death. It will be paid by the trustees of the pension scheme directly to your beneficiary.
Second thing I wanted to ask is, second thing I want to ask, for example, people don't have money to pay for funeral expenses. How is that? How is that paid? How is that raised? How can it be paid in installments? What's the process? Not everyone has got, you know, £2,000 to £4,000.
So if there is a case of extreme hardship where there is no money to pay for a funeral, then the local authority has a duty to make sure that your body is disposed of. Now, unfortunately, that means it will be cremated. So they will not take into account your wishes. Your funeral is always the first call on the estate. So if you're not part of a mosque committee, I don't know if this mosque has a death committee or not. If you're not part of the death committee and your funeral is not paid for by the mosque, then the first call on your estate is the cost of your funeral. So before any debts are paid, before any assets are distributed, your funeral must be paid for. If there's no money even to do that, the local authority will arrange and I can't call it a funeral because it isn't a funeral, they will arrange for the disposal of your body, which means that they will cremate it without a service, but they will make sure the body is cared for.
Just a quick one. What is the life of a will?
Sorry, say again?
The life of a will? Is it for life?
Yes. So once it's made, unless you need to amend it, it's there until you die.
And are you supposed to amend during the period of the will, or can carry on as it is?
Only if your circumstances change. So if you gain more wealth, your tax position may change. If your family expands, so if you have grandchildren or great-grandchildren, then it's up to you. You don't have to, but we certainly recommend that you keep it reviewed. Yes.
Thank you.
Two questions. Can you just explain how a trust works in a will, as to how that becomes tax efficient? In brief.
So essentially, under English law, if you have a married couple leaving the majority of their property to each other and then to their children, then you would have £1 million of nil rate bands that are available to you. Islamically, on first death, because of the way the rules operate, you end up using your nil rate bands on the first death. If you use a trust, you come under the rules which are called the immediate post-death interest in possession rules. There'll be an exam after this. And what that essentially does is it treats the assets as belonging to the surviving spouse, and the surviving spouse as being the person who's distributed those assets Islamically. Therefore, all of the nil rate bands that would have been used on first death are available on second death. So you effectively get the full £1 million of nil rate bands, plus you get the advantage of being able to distribute Islamically from the second person, which is what makes it tax efficient.
Right, okay. Second question, lasting power of attorney. Are there certain conditions under which you can apply for it, or is it open in the sense, for example, I'm healthy, sound in mind, healthy body, but I want to give lasting power of attorney to my child, adult child, in the event that something should happen to me? Is that possible, or does it have to be when the person is not fully able to?
Absolutely, do it now.
Yeah.
Do it today. Mm-hmm. The best day to do it was yesterday.
Yeah.
The next best day to do it is today. You can only make a power of attorney whilst you have capacity. So on the day you lose capacity, so God forbid you had a stroke, for instance, I mean, that could happen at any time, you would not then be able to make a power of attorney. And then you have to go to the courts and apply for a deputyship order. Now, the problem with going to the courts to apply for a deputyship order is it takes 3 times as long to get in place and 10 times as much. And then you're subject to the jurisdiction of the courts for the rest of that person's life. Whereas if you, as you say, a fit, healthy adult, make it now, once it's made, it's there forever. So it's just like an insurance policy, really. It's well worth doing now.
And will it last for as long as the person's alive? Or
the clue's in the name. It's a lasting power of attorney, so it lasts for your whole life.
Yeah. Okay. Thank you.
Okay. What I'd like to do is obviously thank our panel. So obviously, firstly, Sister Mariam, Nick, Hussein, who helped set everything up and is our link with the company, and Mullah Sahib. If you can recite one Surah Fatiha for Kul Marhumi, please. What we'll do is obviously our panel will stay here. If you have any more questions, you're more than welcome to come to the front. They're offering a a 1 hour free consultation, so please come and speak to them, sign up. We have business cards, flyers and stuff to help you. And if you have any questions that you thought were too personal to ask in public, they're more than happy to answer a few questions. We have another event, which is next Friday, again, after namaz, which namaz is at 7 o'clock, and it's funeral administration. So what we'll do is we'll talk through, it's a 8-step process or stage process, and it explains to you exactly what happens at each stage. So you know, and unfortunately, if you're one of the unlucky ones and you've been through it, you know, but if you haven't been through it, it's a good idea to learn. Emotions run wild during everyone's emotional sort of thing. So it's important if you, while we have a level head, you understand the processes that take place. And is there any other? No? Last time?
Just to end with dua only. Okay? Right, so again, I want to take the opportunity to thank Mason, the committee for organizing this seminar, and to thank you all, especially our guests here, for coming and participating in this program. I request you all to please join me in this dua. Bismillahir Rahmanir Rahim. Allahumma anfa'na bil ilm wa zayyinna bil hilm wa jammilna bil afiyah wa karrimna bit taqwa inna waliyya Allahu alladhi nazzala al kitab wa huwa yatawalla as-salihin walhamdulillahi rabbil alamin. Allah.
Yeah, that concludes tonight's event. If I can just ask you, if you've got a plate or a cup, there's a bin outside. If you want to grab some more food, please grab it. We don't charge for containers.